in our one of the memorial session, R.L. Sanghvi memorial talk. Would request everybody for the departed soul, if we can have a 1 minute silence, if we can rise in our place. Om Shanti. Thank you very much. I'll request Rajiv sir and Jatin bhai to take forward.
હું પાછી નીચે જ આવીશ. Good evening, everybody. Today it's really a great event to be, more so because, of course, the subject, we have the dignitaries who are experts who are going to be talking about it. It's an event which is in collaboration with AMA and FICCI. And I'm fortunate that I'm connected with both these institutes. So it gives me an additional pleasure, as well as I'm very happy about it. So that's something which is definitely a great thing today. Good evening, distinguished guests, esteemed panelists, and ladies and gentlemen. It is my distinct honor to welcome you all to today's panel discussion on the critical topic of new criminal laws. We are privileged to have with us an exceptional panel of legal experts, each contributing extensive experience and specialized knowledge. I would like to take a moment to introduce these distinguished individuals who will be sharing their insights with us today evening. Firstly, we have Mr. Mitesh Amin, Additional Advocate General and Senior Counsel at the Gujarat High Court. We are joined by Mr. Sanjay Thakkar, a senior lawyer at the Ahmedabad City Civil and Sessions Court. We are also honored to have Mr. Ankush Mehta, partner, White Collar and Investigation, Cyril Amarchand Mangaldas, Mumbai. Lastly, Mr. Kapil Arora, partner, Disputes, Cyril Amarchand Mangaldas, New Delhi. Today's session will be moderated by Mr. Jatin Jalundwala, whose experience in managing complex legal dialogues and his keen understanding of legal issues will ensure a dynamic and thought-provoking discussion. The knowledge and experience of our esteemed panelists will help illuminate the path forward, and I'm confident we will all leave here today with a deeper understanding of the complexities surrounding this crucial subject. We now proceed with the felicitation of our esteemed panelists and invite them to, of course, they're already on the stage. So we'll just start with the felicitation. First, we'll have Mr. Mitesh Amin. Next, Mr. Sanjay Thakkar. We have Mr. Ankush Mehta. Of course, Mr. Kapil Arora. Yes, we have Mr. Jatin Jalundwala. No, but I mean today he has put in lot many efforts in doing the whole thing, and I mean it's as much as you are important over here today for this event as everyone over here. With this, I hand over the baton to Jatin Bhai. Over to you, sir.
Hello. Good evening, respected Mitesh Bhai, Sanjay Bhai, Ankush, and Kapil ji, my colleagues from FICCI and AMA, and participants at today's event. This is a kind of event which we have organized today, which is on the criminal laws. Because we all try to have the idea about the civil laws, arbitration, GST, but we never have thought of the criminal laws, what we should have the idea about the criminal laws. So before I start, I would like to introduce all the panelists more in detail. Mitesh Bhai is Additional Advocate General and Senior Counsel at Gujarat High Court. He has been in practice since 1984, initially working in trial courts, and has built an impressive career across both criminal and civil law. His legal expertise spans several decades, having started on the appellate side in 2001. His career reached a significant milestone when he was appointed as a public prosecutor in Gujarat High Court in March 2015. His exceptional contribution to the legal field led to his appointment as an Additional Advocate General in December 2023, a role in which he continues to serve with distinction. Welcome, Mitesh Bhai, again. Sanjay Bhai, he is a senior lawyer at Ahmedabad City Civil and Sessions Court. For us, I am telling him as in-house counsel for us also. A lot of things, whenever we have, me and Rahul always try to call him, Ke Sanjay bhai, shu karu. So he has been always path to us. Sanjay bhai has been in practice since 2002 with a focus on criminal law in trial courts. He began his legal journey with a brief stint on the civil side in trial courts before dedicating his practice to criminal law. He has extensive experience in criminal litigation and has regularly appeared before the Gujarat High Court, particularly in criminal matters. Over the past 2 years, he has been representing the state as a special public prosecutor in cases under the PMLA, further enhancing his specialization in financial crimes and complex criminal cases. Welcome, Sanjay bhai. We have with us Mr. Ankush Mehta, a partner, white collar and investigation, Cyril Amarchand Mangaldas, Mumbai, who is having about 18 years plus experience of advisory and litigation. Specializing in corporate and commercial disputes, he focuses on white collar crime, arbitration, insolvency, and succession law. He represents domestic and international clients in a range of sectors, including infrastructures, construction, and real estate. He regularly appears in arbitrations and courts, including the High Courts and Supreme Court, and advises clients on criminal matters before various investigative agencies. He has been recognized as a recommended lawyer for white collar crime by Legal 500 2023 and a future star for commercial and transaction by Benchmark Litigation 2023. Welcome, Ankush. Mr. Kapil Arora, a partner disputes Cyril Amarchand Mangaldas, New Delhi. He has come all the way from Delhi, and Ankush has come from Bombay today, especially for this conference. Kapil is a seasoned expert in dispute resolution with over a decade of experience, specializing in domestic and international commercial arbitration and litigation. He regularly advises multinational companies on engineering disputes, power and infrastructure projects. He has successfully represented leading corporations in corporate fraud and white-collar crime cases, including high-stakes international arbitration with claimed exceeding $300 million. He has appeared before the Supreme Court of India, high courts, and international arbitration bodies like ICC, handling disputes across EPC contracts, joint ventures, and bank guarantees. Welcome, Kapil. Thank you. So now let me start the session, the actual subject matter of today's, that is new criminal laws. You all know previously 3 laws were there. That is IPC, Indian Penal Code, Criminal Procedure Code, and Law of Evidence. Now all these 3 laws have been replaced. It's not possible that one law is replaced for other, but all the 3 needs to be replaced together. And 3 new laws have been introduced, which has been called BNS, BNSSS, and BSA. If I tell Bharatiya Nyaya Sanhita, that is IPC, Bharatiya Nagrik Suraksha Sanhita, that is Criminal Civil Code, and Bharatiya Sakshya Adhiniyam, which is Evidence Act. These are the 3 new acts which have been replaced by the old laws, and that has been made effective from 1st July 2024. So it is essential, first, we must have the idea about what are these new 3 laws and what are the main changes, major changes introduced in these 3 laws. And therefore, I request first Mitesh Bhai to give us idea about these new laws and what are the new changes vis-a-vis the old laws. Mitesh Bhai, you can. Okay. Yeah, thank you, sir.
First of all, thank you very much, AMA, FICCI, Mr. Rajiv Bhai, Mr. Jatin Bhai, Mr. Ankush, and Mr. Kapil, and all the esteemed listeners who are present here and have given their valuable time to listen about the 3 new laws. Well, we are in the regime of 3 new laws now almost since 6 months. I would say it is not simpliciter a change of names, but there is an element of replacing justice to the punishment so far as Nyaya Sanhita is concerned. So far as procedure code is concerned, there is an element of protection of citizens in it. And Sakshya Sanhita, that is the Evidence Act, as now we live in the regime of digital world. And probably by 10 years from now, it will be more a digital world than the physical world. And therefore, how to prove the electronic material, how to prove digital material, that is the computer output, that would be an issue which would be discussed in not only courts, but in every walk of life. And therefore, let me begin with what are the changes which are made in these 3 new laws. If some brief statistic is required to be given, then there are about near to 1100 sections in all the 3 statutes. And the major change has happened in Bharatiya Nagrik Suraksha Sanhita. There is a major change in it. The second major change has happened in Bharatiya Nyaya Sanhita. And lastly, very few changes have happened in Bharatiya Sakshya Sanhita. So if I can just briefly narrate what are the changes in Nagrik Suraksha Samhita, then not only for the persons who, etc., then the first major change which I would certainly applaud is that for registration of FIR, a personal visit to the police station is not required. So if I am aggrieved for any offense which I had suffered, which is a cognizable offense, then certainly sitting at my home, I can give my FIR, and within 3 days thereafter, I can put my signature on that first information report. So for each and every citizen of our country, this is an act which the legislatures have considered to see that their time is saved. They have not to suffer any agony of visiting police station, refusal of their information being not registered, etc. So that, according to me, is the first major change which has happened. Secondly, going little legal on the subject, then with regard to default bail, when I say default bail, necessarily it is not that on non-completion of statutory period of investigation, the accused persons are granted default bail. But very relevant element which I can see in the new Samhita, that is Nagrik Suraksha Samhita, on the issue of default bail is, previously we had a regime or we had a provision that if the total period of punishment is, say for example, 10 years, and if the accused has suffered incarceration for around 5 years, that is half the period of sentence, then by default he would get bail. That was the provision which we had earlier. Rather, the provision or the necessity to enact that provision, because that was not the provision in the 1973 code, that came by virtue of an amendment few decades later to 1973. That was to see that the accused who languish in jail have not to suffer their incarceration for a period which would be more than one half of the total sentence to which they are supposed to be sentenced if at all they are found guilty. So to see that the languishment in the jail is reduced and they have not to suffer. Now there is a change in this particular provision, and this change relates to now that element of one half sentence has been changed to, it would not be applicable to the cases where the punishment is life imprisonment. Because as per the new statute, life imprisonment is the remainder of the life. So that aspect has now gone. The third aspect, well, there are other issues as well, so I will try to reduce my speak on the issues, or rather on the 3 different statutes. If I have to say more about it, then there is an element of zero FIR. Now, zero FIR element was already there in practice, but now it's a statute, inbuilt statute we have. So if I had suffered some agony or some criminal act at Kerala, and I am at somewhere in Madhya Pradesh, then I can very well register my FIR anywhere within Madhya Pradesh or the place where I am situated. And thereby, I have to save myself from the agony of traveling to Kerala or any other place for the registration of FIR. So these are the few aspects about the Nagrik Suraksha Samhita. Now switching over to the Nyaya Sahita, from the word or the term itself, Nyaya Sahita. Previously we had penal code, that is punishment, and Nyaya, that itself shows that there is an element of delivering justice. Well, that does not mean that it has become friendly legislation. Certainly it cannot be friendly, because we live in a world where there is more crime, and it is increasing day by day, not only in our country, but entire world. There is an element of criminality somewhere or the other. So there cannot be a friendly penal law, but there has to be an element of delivering justice, which is there in this Nyaya Sahita. Therefore, the most important facet which I see, or which I can read in the Nyaya Sahita, is the introduction of organized crime in the Nyaya Sahita. Well, we have the first state. My friend Mr. Ankush comes from that state. That was the first state somewhere in 2001 or so. Makoka, that is Organized Crime Act, was introduced by the Maharashtra state. Thereafter, it was adopted by Delhi. Few other states had also that particular state legislation. And we have Gussi Talk since 2019 rather. But now introduction of organized crime is to meet with the challenges which we used to see, or which we used to suffer day in and day out. Gone are the days where the crimes were happening between two persons. That was one an aggrieved person and the other is the culprit. Today, in the world in which we are living, we live in the world of contract killing. So the actual killer would be sitting in an ivory tower, and the hirers who have been hired by him would be executing the act of murder. So we live in a world where the actual culprit or the main culprit is behind the curtain or is in shadow, and the tools or the contract killers are on the field to execute the conspiracy which has been hedged at the behest of the main culprit. So therefore, considering such type of increased activity, Nyaya Sahita has thought fit to introduce organized crime. Now this organized crime word is very broad, and therefore we had an inclusive definition which includes kidnapping, extortion, so many other different crimes have been included in this organized crime. It can be committed by two or more persons. And today in the world in which we are living, most of the offenses are committed by at least two or more persons. Gone are the days that one single person would be committing an act of the murder. So very rightly, it is now not a state-specific law, but it's a country-specific now. And therefore, introduction of organized crime, according to me, is required to be welcome. And lastly, though I can say so many things about it, but coming to the last act, that is Sakshya Sahita, as I said that we live in the world of digital, and gradually it would be increasing day by day. So how to meet with this digital evidence, the computer output? So Sakshya Sahita, there is a provision as to how to prove such type of evidences which comes before the court. There is a requirement of some certificate, etc. But well, we are in a nascent stage. When I say nascent, I don't say that it is really nascent, but it's a term which I would like to use it would gradually develop. And by few years from now, we all will very know by heart that as to how this electronic evidence or the digital evidence can be proved before the court. So, friends, there are other esteemed speakers. So, I would end so far as introduction is concerned. So many things I can dwell on, but on some other day I would like to.
Thank you, sir. You have given a very brief introduction and highlighted the main provisions of these three new acts. And one of the points which is touching to everyone and to me, that previously it was called penal code, that is punishment code. And now the word is used nyaya. So everyone needs to be given nyaya. That is the most important part Mitesh Bhai has brought to our notice. Now, I just would like to know from Sanjay Bhai, because he is day in, day out doing the work at Sessions Court and Magistrate Court and other places. How do you find, Sanjay Bhai, that these three new laws have impacted speed, efficiency, effectiveness as far as today's situation is concerned?
As am I getting it? See, the very basic objective, as it seems, is the time-bound delivery of justice. So, on that context, the first part would be of investigation. And before I say something on investigation, that what is offense? It is act or omission. Act, doing something which you are not supposed to do. Omission, which you are supposed to do and not doing it. So the criminal law comes into motion. So along with time boundness, the another objective and desirability seems to be the credibility in the investigation. Now, as far as Amin Saab has said regarding the zero FIR, the first thing, the lodgement of FIR, etc. Now, there is another thing, side by side we come across that there are some, we can say, there are some false litigations or false cases. So there is something now coming in this law that there is a scope of preliminary inquiry of 14 days just to verify the substance of the allegations. And secondly, what we are concerned more or less in common parlance, the word arrest. And there seems to be very little awareness so far, because there are two types of offenses, bailable and non-bailable. Moment someone is coming across to the criminal law, he or she might not be knowing or not be aware or not getting aware also. There are many offenses bailable. Even investigating officer is bound to inform you at the time of arrest, this is a bailable offense. If you are ready to furnish bail, you are supposed to be released. There is no discretion in it. Now, coming back to the point of investigation, day in, day out, as initially we were on the point of adaptation of technology. Now we are shifting towards the technology. And in the shifting path, there would come a end that we would be totally using or depending on the technology. So even now the investigating officers are authorized to use their own mobile phones for recording something related to collection of material or evidence as far as the alleged crime is concerned, which was not heard any time before. Of course, the authenticity is another aspect of that recording, etc. Even some search, seizure, the recording is mandatory. This is on the point of seeing the maximum credibility is attained. Now, so as far as the another aspect which we see in the common area, that the person raising the grievance or giving information, whether he is aware of the progress of investigation or not. Even there are now provisions that timely awareness regarding the progress of investigation. And when I said the word progress, then what is the quality or credibility of the investigation, that can also be known. Now, post-investigation, since the investigation is completed, coming on the second aspect of prosecution, as Jatin Bhai asked regarding time, etc. Moment, and nowadays, even the summons or warrant can be issued electronically. And this word electronically, audio, video are part of the definitions in the subjected clause. So, the purpose of issuance of summons or warrant is like that it should come to the knowledge of the person concerned, either as an accused or witness, that he has to participate in justice delivery system. So time is saved. Secondly, the committal proceedings, there are some offenses which are exclusively triable by court of sessions. So now there is a time limit. Within 19 days, the case has to be committed. And beyond 90 days, some window is provided, but subject to reasons, recording of reasons. Now, coming to the prosecution side, moment the first hearing is commenced, within 60 days, charge is required to be framed. And the another anxiety of the litigants and other the common people is that when the judgment would be passed. Even now, there is a provision within 30 days, and outer limit is 45 days. The judgment has to be delivered. Though in the new law, it is specifically mentioned in sessions tribal cases. But if we look to the chapter of word judgment, it is also there. So it applies to all criminal trials. So we can witness nowadays, time would be saved, because as far as the time consumed in the investigation, post-investigation, the service of summons, warrants, etc. Post that, the proceedings of trial, and even now, audio, video means and electronics are to be used as far as the recording of evidence is also concerned. So even the charge can be framed by audio, video means. So the lot of time could be saved.
Thank you, Sanjay bhai. This clearly shows that while drafting these new laws and while implementing, the government has also taken into consideration what difficulties have been faced by either side, complainant as well as accused. So coming back to what Mitesh bhai has said about the organized crimes, I would like to know from Ankush, what is the organized crimes? Like vehicle theft, kidnapping, and what are the provisions? That the first time organized crime has been defined under section 111 as an inclusive definition. What you want to just highlight on this subject, organized crimes?
So thank you, Jatin bhai, and hi to everyone. I'm conscious of what Mr. Amin talked about, so I will try and give a slightly different perspective of organized crime, which is covered under Section 111 of the new Act. It also includes, of course, economic offenses, and it also includes cybercrime. Now, as we all know that Maharashtra, Gujarat, have their own, organized crimes laws. In fact, very recently in 2024, the state of Andhra Pradesh relied upon these two laws and, talked about how organized crime is to be interpreted in a criminal defamation case as well. Talking about cybercrime effectively is, as we all know today, cybercrime under the Information Technology Act is any act that happens through the device. It could be your mobile phone, it could be your iPad, it could be your computer, it could be, you're having a virtual meeting, etc. So that is something very significant, because in my view then, going back to what Mr. Amin also talked about, that this person sitting in an ivory tower, it could be sitting anywhere in the world, and such an action or such an offense can happen. So that's point number one. Point number two, just to add to what Sanjay bhai talked about on technology, I want to split this discussion in two parts. One, how technology is effectively used in the process of the investigation, right from filing a complaint, your online FIR, to the fact that you can call a witness or somebody for a statement. You don't have to visit the police officer's office now. You can give it virtually. Conducting of forensic investigations through technology, recognition under the Bharatiya Sakshya Adhiniyam of primary evidence, which is your new 63(4), and what are the inclusive and larger definitions of primary evidence, such as video recording, storage, etc., etc. More sanctity to what earlier was the 65B certificate, which we all knew commonly, but today there is a 63(4). And of course, one important thing that I think we all need to know, that whether the conducting of trials through virtual means is really sacrosanct. I think it is important to understand this, because as we go back in time during the pandemic period, other than the criminal courts, there was no court which was not working physically. People had moved to virtual means, people had moved, and the criminal courts were sort of still working in physical form. According to me, there's a reason for this, is that when you are conducting trials and the witness or the accused are there in custody or in prison, and if they're going to take their evidence or their testimony or their cross-examination through there, what is the sanctity when tomorrow he wants to consult with his lawyer, that that ability is there and it's not getting tapped and that confidentiality is not getting compromised? I think these are some of the important things that one has to keep in mind. On the other hand, it would be fair to say from my side that while there is use of technology, I think we should all think about it whether there is a question of misuse or abuse of technology as well. It's all very well to say that we will be advising our clients and we will be filing these FIRs, etc. But the reverse is also true. That person sitting in MP will also file that same complaint against you and make you run around tomorrow. And that technology will not come to your advantage. Number two, yes, when clients come to us and we are advising of recovery of property, Kapil, we all advise on these things. I'm sure all the gentlemen on my right advise on these issues, right? And you say that, okay, I'll file a police complaint. This guy will go to the police officer, and then, maybe there'll be a threat perception. But tomorrow, if he realizes that I can give this statement virtually, is the threat perception still going to be there? So there are various other things on, what we have to keep in mind, that, even a zero FIR, even an online FIR, these are available to everyone at large. So I just want to end by saying that there's going to be, according to me, these laws are here to stay. We'll have to move cautiously because there's a lot of awareness, a lot of learning through these sessions, which is happening. And I just want to leave it at that. Thank you.
Thank you, Ankush. Most of the crimes are organized crimes in the world. So next question is a very interesting question. I think you all will like, all are definitely interesting. But there was always a kashpakas when the new act was introduced, even to the authorities, with due respect to the lawyers, even to the lawyers, that which act will be applicable? IPC, Criminal Procedure Code, or 3 new laws. Say 1st July 2024, it was introduced. I think Mr. Kapil will be the right person to give us the idea, because what I want to just give one example. So there is a crime which has been committed before 1st July. And I want to register the FIR thereafter. Which law will be applicable? Secondly, sometimes some cases are going on under the IPC, then how cases will be dealt with? I request Mr. Kapil to just throw some light on it.
Thank you, sir, for this question. See, thankfully, the courts in India works exceptionally well. Though the new laws were introduced on 1st July, not only the general public, in fact, the lawyers was also in a dilemma, how are we going to use it? Because it takes time for the lawyers and the judges also to digest and interpret laws. And as Jatil Bhai was asking, that was the first question amongst the lawyer we were asking. If the crime happened after 1st July or before 1st July, what are we going to do? But thankfully, there are judgments to this effect, which has made life easier clear, and now it is well settled principle which has been recognized by the High Court says if the offense has been committed by 1st July and if you are registering the FIR after the 1st of July, the FIR still will be registered under IPC, which is the older version of the Indian Penal Code, not the new version. But there is a benefit which the accused will get. Though the FIR is registered under the IPC, the procedure which is going to be followed for the purposes of arrest, investigation, and the trial will be as per the new CRPC. Similarly, for the cases which are pending since past and the trials are going on, wherever the trials were pending, they will continue with the older version of CRPC. The new CRPC will not be introduced. The trial will not be interfered in between. But as and when the trial is over and an appeal or a revision is filed, then the new law will be applicable. So now the position is very, very settled that how is going to be applicable and what is to be done.
Thank you. So that means suppose a case is going on under IPC, and you know, in India, some of the cases we are reading in the newspapers, a person at the age of 80 years, he was ordered to be jailed. And when the crime was committed, when he was at 40 years. So in such situation, IPC law will be continuing for number of years. Is it right?
Yes. In fact, we have seen certain cases in Supreme Court where the person has committed the crime in his youth, which is 20, 21, 23 years of age. And his matter is still pending before the Supreme Court when he is 80 years plus or something like that, sir. Because that's the time in the older version, the high courts have taken time in the settling of the appeals. If you go by today, I don't know about the Gujarat, but if you see Delhi or Mumbai, where the pendency is so large, as on date, Delhi High Court will be hearing 10 years back appeal. And Bombay High Court will also be hearing 10 to 15 years back appeal. So when your number will come, when your appeal will be finally decided, and then if you go to Supreme Court, and if day one your special leave petition is admitted and it becomes a regular appeal, even God knows when it will come for hearing. Because there is so much of new matters, all the backlog remains the backlog.
Right.
That's the irony of the Indian system. But still, the courts are doing well. Whatever they're possible, each and every court is dealing with 100+ cases, which is nowhere in the world except in India, where the judges are capable of handling 100+ new matters on everyday basis.
Thank you. So to make much more lighter, I'm just reminding one thing. Say a judge was asking some questions to an old man. He was at around 75. It's a joke. It's a joke. That he says, कि यार इतना आप 75 years old हो गए और ये लड़के की मस्करी कर रहे हो आप, शर्म नहीं आती आपको? He says that this event has happened when I was at 40 years of age, and today I have been brought here. So coming, Mitesh has told about the EFIR. Now it is becoming very important for us that we may not have to go to the police station, and sometimes it has become difficult to get the FIR registered at the police station. धक्के पे धक्का खाओ, फिर भी FIR नहीं register होती unless you have some weight. Now I just would like to have idea about for Sanjay Bhai, what is EFIR and how it works?
See, initially, Amin Saib has explained the filing of EFIR through your electronically. See, moment it is filed, then within 3 days, the informant has to sign it. And even before this amendment, the signature of the informant is mandatory. Supplying him the copy of FIR free of cost is also mandatory. It was also then. And as there seems to be anxiety, the moment you are filing AFIR, whether it is a right one, wrong one, correctness is there or not. So this 3-day period seems to be as an objective to see that the person who is filing electronically is the same person who is signing it. So just to save the time, and it seems that time is always an essence in terms of the aspect of investigation as well as prosecution. Moment it comes to the knowledge of the concerned police officer that something has happened or something is to be happened. If an offense is already being committed, then the detection parts come. If something is to happen, then the prevention of crime parts comes. So it always helps in terms of time, speed, etc. Because moment it comes to the knowledge, he can also act upon quickly.
Sir, are there any e-portals provided where I can file the e-complaint? Or it is just a provision and I really, in practical work, cannot do anything?
See, as far as now contexting this issue with the filing of zero FIR, suppose if you want to file any FIR, let us say by electronic means, so you can file it to the nearest police station. So if at all there is no portal for a moment or it is there, you can file to your on email ID or the website of the nearest police station.
Can I find out the email ID anywhere where I can find file the complaint? Probably no.
It's available now. Each and every police station, you will see the email ID is available.
Because even today, if you go to the police station, if a small complaint is there, they will say, "Kya complaint karna hai? Bhul jao." Or otherwise, if I tell you this way, then you file accordingly. But if I want to file a complaint in my way, it will not be accepted.
Also, these portals are working very well now. In fact, in Delhi, NCR, the portals are also there. And if the portals are not there, the email IDs of all the big police officers and their rank wise also available. In fact, you would remember there were the days when you lose certain papers and you need to register an FIR. For example, you have lost your property documents or a passport or the other things. Now it's very easy. You go on the portal, register that you have lost your passport. Within 1 minute, you will get the registered non-cognizable FIR with you, which you can use as a document, and you don't have to go to the police station. So the government is trying to make your life easier. They started with ease of
If that
business.
really works,
In fact, same
It's
for cyber complaints.
Yeah.
Right? When you get hit by any deepfake, any phishing, hacking, any inquiries, the portals are extremely active and supportive to lodge your complaint immediately.
I don't know, my experience was very bad. Some 3 months ago or 4 months ago, when I had tried, it was actually not taking. Even on phone, it was not. No one was coming. So that was really. Okay.
In a lighter
So
way, this
it has
actually
been
happened.
made more effective now.
Just
Going to the
just
next.
one incident, since you mentioned lighter way. So we had gone to a police station to register something for a client.
Yeah.
And so we got talking, this was late at night, and we got talking and then we got sort of built a rapport with the police officer. He told us, lawyers ko bhi hota hai issues. I said, I didn't understand. He said, magistrates are बैठे उधर उनका भी बैंक account है.
Sir, are there any provisions now how to conduct a criminal case? Can it be expedited in any way?
Sir, I think some questions are coming that way, and that you can ask my request to you, because otherwise the flow will not be there. And you will find out all the questions, your reply in all the questions mostly. Yeah. So, next question, one more is also an important one. When the summons are issued, if you see section 138 of Negotiable Instrument Act, summons have been posted to the person wherever he stays, but it comes always back. His person is not available, house is closed. So it happens number of times, such things, and it is very difficult for a person to get a justice. In such situation, I would like to know from Ankush, now serving of the summons virtually is also possible, like WhatsApp or email. Can you just highlight?
Absolutely,
Yeah.
absolutely. I think we talked about the growth of technology, and it was only sort of fit that the new criminal laws and the evidence law, in fact, recognize how technology is to be used and summonses to be served. In fact, I'll take a step back and say even 1st July, prior to 1st July 24, there were enough cases where through WhatsApp or through emails or various other digital means, summons, intimations were served. Very often a police officer, if he wanted to serve a notice on you, would ask for your WhatsApp address and serve it. Now, at those points in time, and I'll just answer this question again, but at those points in time, how many of the clients really would want to say, you know what, the summons has come by WhatsApp, I'm not answering it? I don't think any of us would do that, right? We know that there is a summons which has come, and we know we need to attend to it. Yes, it may not be the formal means as per the CRPC then, but fine. On talking about WhatsApp, talking about email, I think it is only a validation or recognition of the processes being followed. Because today, when you talk about enforcement agencies across the country, sometimes even abroad, and other regulators, email is the safest, fastest, and most sure-shot way of this to reach. The problems that happened when you couldn't find a address in the country, or you couldn't find the person at that address, those problems are negative. So I think it's the step in the right direction. And effectively, one case in Madras that comes to my mind is in a matrimonial case in 2019, which was proceeding, and there was obviously cross evidence between the husband and the wife. Uh, the amicus curiae who was appointed by the court, in fact, requested the court that because you have the new act right now, he pleaded to the court, and the court made an exception to say that he will now try this matter as per the Evidence Act under the new law, except one condition he sort of made, to which that he said all the processes therefore, 63(4) and other things, will also happen as per the new law. So there are courts who are sort of amicable, there are courts who are sort of open to also trying these things. Okay.
Say, in today's world, corporates are facing one difficulty. Most of the corporates are top corporates in India. I would like to have guidance from Mitesh Bhai. The subject is fraudulent job offer or sometimes fraudulent franchises offer. Let me tell you, at Adani, somebody comes to our place with an appointment letter and says, okay, today is my joining date. To whom should I meet? Then he comes across that this appointment letter is a fake one. And we have registered certain criminal complaints at police stations. At some places, the police visited the place, offices. When we go there, either offices are closed. And in fact, one or two cases, the culprits were arrested also. But Mitesh Bhai, it's a day and day out problem. I just would like to have your guidance. Whether section 111 covers this and what remedies corporate has to take.
The question, as I understand, is this: that if there is a job letter which is fraudulent, if there is a job letter which is fraudulent, then what is the remedy or what is the offense committed by the author of that particular fraudulent letter? Now, in context of this, if one examines the definition of organized crime along with petty organized crime, because we had organized crime as well as petty organized crime, and if we see both the penal sections together, it includes so many offenses, one of which is economic offense. In today's world, we had large scale frauds on examination papers. We had lottery scam. Previously, we had not heard about it. And offense would affect large number of persons. So when you are saying that there is a fraudulent job letter, I don't think there would be one fraudulent job letter. Otherwise, it would be very easy to name the person who had created that fraudulent job letter. So in a big company or a big corporate house, there will be large number of such letters, if at all such letters are to be created. And therefore, by examining the definition of organized crime as well as petty organized crime, which includes economic offense, which also includes to an extent criminal breach of trust, cheating, etc., then closely examining this definition, this offense would be covered by this particular two penal sections. When it would be affecting large number of persons, because the aggrieved party will not be the corporate house only. The aggrieved party would be the actual job seekers as well.
Yeah, right.
Considering it, both the sections, if closely examined, there is an answer that which offense is committed.
Right, sir. Thank you. I now go back to one more point, like police search and seizure. Sanjay bhai, I think you might be experiencing day in, day out. So, what are the provisions under the new act for this search and seizure? Is there any unlawful search and seizures, and what remedies are available to the accused?
See, in the earlier law, the seizure part was there. As far as search warrant procedure regarding any female is affected or any property stolen or subjected to the commission after commission of the crime is hidden over there. So search part was also there. Seizure part regarding police officer during the course of investigation seizing some property connected with the crime, he has to report to the concerned magistrate, etc. Now in the amended law, the provision regarding attachment of property is also there. Now this attachment of property, of course, connected to the crime being committed, some sort of involvement, discretionary involvement of the magistrate is also there. Suppose if any property is required to be attached connected to the crime being committed, then the application is given to the magistrate. Magistrate calls upon the subjectee of whose property is the matter of subject. He can have his say, but in a given circumstances, an interim orders can also be passed. So the new provision regarding attachment of the property is also there.
Kapilji, a question related to search. When a person is being searched, what provisions or protections are available to that person? Say, for example, I have been told, okay, when your mobile is taken away by the police, in that case, police can take away your mobile, but cannot compel you to give the password. Is it correct? Or what you can just add to this?
Yes, sir. See, search and seizure initially was the domain where police used to misuse it sometimes because this is an immense power. Right? If police today enters your premises and wants to search and seizure, the first thing which comes to the impression is they are police, you can't stop them. They are the one who can take away each and everything. I guess first and the foremost protection what a corporate has to see is or an individual person has to see is whether the police has the requisite search and seizure warrant. Do they have the authority to search and seizure? In fact, now sometimes you will see if the magistrates are so specific, they'll issue a specific order under what search and seizure they can carry out within the complex. So if you have a building of 8 stories and all 8 stories is your office, sometimes the search and seizure will only have the first floor. So you cannot allow police to enter the rest of the 7 floors. And what Satyabhai was saying, I will also take that forward. For the first time under the criminal law, which was the attachment of property is there. So which is the immense power which has been given to the police. Earlier this power was only available to the ED when the prevention of money laundering was involved. But I guess the most effective sector would be the real estate sector. The moment you start attaching the real estate of a builder where there is allegation of crime, the police doesn't have the power only to attach it, and in case if the builder is committed at the end of the trial, the court will also have the power to sell that property and give that money to the home buyers. And what you were asking the specific question was, as a matter of right which has been given to us by the Constitution of India, you are not supposed to give your passwords, whether it is for your laptop or the mobile. In fact, there are two latest examples for this. Mr. Kejriwal refused his password to the cops, and nothing was held against him. And in fact, for the first time recently, on 13th of December, Supreme Court is examining this issue, where the ED was compelling someone that they will take over the entire data from their iPhone. Supreme Court has restrained the ED not to interfere with any of the data they cannot take. So in this modern age, I guess it's very, very important for you to have your iPhone and laptop passwords instead of your face recognition. If there is a face recognition, police will somehow take it.
Sorry, I just have something more to add. So, as Jatin Bhai rightly put and Kapil has answered about, privacy or personal details, there is another concept that was there earlier but is emerging now. What is called the concept of the right to be forgotten. Now, what is this right? Basically, if you are exonerated of a case, right, and but in social media, across the internet, there would be details about the case and so on and so forth. This started in Chennai and Kerala, and very recently the Delhi High Court. In fact, the names are disguised again because the fact is right to be forgotten. So it was an ABC versus so and so, and where the court set out that today social media could be, your WhatsApp, your Facebook, etc., etc., and it set down parameters as to that if this person has been discharged of a case, every single place in the World Wide Web where this person's name is shown is meticulously taken down. So I think that's a very important concept in the right. It goes back to our constitutional freedoms and right, that otherwise there will be a social taboo, a sabotage at all points of time. You'll be explaining to your employers, your family, your to-be wife, your to-be husband, God knows, right? And these are very, very sensitive and important things that I think are required. So yeah, the Delhi High Court has said.
Ankush, a question to you now also, because Sergeant Caesar. After that, a small question or more question, which is of arrest. What are the new provisions or changes which has been made in the new law for the arrest?
So I think Jatin Bhai, great question again. Two things. One, more or less, the laws haven't changed that much in process. Talking about anticipatory bail, in my understanding, the discretion given to the judges a little more. There has been some resentment or debate or dialogue on the staggered custody bit, right? How it is to be spread out depending on the type of the offense, and therefore, the media or the negative views that are coming on this is that there's too much power in the hands of the police and it's not being held responsibly. There are also certain other relaxation provisions in my view, where if a person has served 1/3 or 1/2 of their sentence, then an application can be made by the Director General of Prisons or equivalent to have a sort of the person to be released on certain conditions. So those are the few things that I thought are relevant.
Okay. Sanjay bhai, considering this arrest, we would like to know about what are the rights available to the arrest person during the police interrogation and thereafter, even at the time of bail. Say previously we were talking about putting to discharge and other things, and even at the time of arrest also.
See, as far as arrest is concerned, the person arresting is required to make it clear in the nature of accusations of which had been the reason for the arrestee. So the nature of accusations are to be explained. As I said earlier, the bailability, non-bailability of the subjected offense. Apart from that, during the course of interrogation, he has a right to meet his lawyer, of course, not throughout the duration of the interrogation period. As far as the maximum detention period, that it is of 24 hours. Within 24 hours, for any further custody, if at all is warranted, he has to be produced before the concerned magistrate, even otherwise also. It is not released on bail or released, and even depending on the circumstances, even in non-bailable cases, if at all there is nothing in terms of sufficiency of evidence, even in non-bailable cases, police can release the accused after taking due bond. And any arrestee has been protected constitutionally cannot be a witness against himself or herself.
So nowadays we are seeing more cyber crime. Physical crimes versus cyber crimes, if you see, the rates of cyber crimes have gone up substantially. Would like Nidesh Bhai, if you can help us to throw all lights about the cyber crimes and the provisions for that.
Let me just, I have already examined, but your question relates to cybercrime, and I am sure this element of cybercrime is also there within the section organized crime as well as. So, as I said, or rather I started by saying that the introduction of the offense, organized crime and petty organized crime, introduction of the offense of organized crime and petty organized crime, which is an inclusive penal provision, which would include an act of kidnapping, extortion, robbery, theft, now breach of trust, cheating, and many more terms. And one of the term is cybercrime. Well, there is not much elaboration on it, but cybercrime certainly is a part of the organized crime. So there are variety of cybercrime happenings day in and day out. One such type known to me is, and few of my friends are here in the audience who are my esteemed colleagues in the High Court, surely would be knowing about it. If I give an example of such cybercrime, well, just to make the question and the answer little interesting, I had come across a case where in a social platform, a person is induced to invest very small amount of, say, 500 or 1000 rupees. And the element of inducement for such investment is that if a person is investing 1000 rupees, he will be getting 2000 rupees within a week. So I am tempted, everyone would be tempted. So he invests, he gets 2000 rupees. Then there is another offer, again in a social platform, that now you have already gained a good amount within a short period of 7 days. So we are now again offering you that invest 10,000 rupees and you will get 20,000 rupees within 10 days or 15 days. He gets that 20,000 rupees. Now that I am already trapped, I am receiving an offer that I have done very small things and now I am meant for a big things. So invest a huge amount. For me, a lakh, amount of rupees 1 lakh is a big, so therefore I invest for 1 lakh rupees. And moment I invest 1 lakh rupees, that social platform would vanish from the my computer window. I am not used to computer, but therefore I am using the term computer window. So that is the act which is suffered by me. And during the course of investigation, I came across that this has happened to thousands and lakhs of persons in the entire country. And the total amount of defrauding large number of persons is beyond 100 crores. And this has happened not only in Gujarat, but in every part of our country. The further modus is this: after I invest 1 lakh rupee, that site would vanish, and the account in which I would have deposited would be a shell company. Shell companies are meant for such type of deposits. Bank accounts are also run fraudulently. And ultimately, after getting a huge kitty of say 100 crores within a span of around 15 or 20 days, the entire amount from different say 20 bank accounts which are run fraudulently, which had an account holder would be either a peon or an ordinary clerk. That amount would be transferred electronically to somewhere sitting in Taiwan or somewhere sitting in some other country of the world. And that is how cyber crime happens. So this is not an act of one person. One person cannot do this. So therefore it's an organized crime. And therefore I say the cyber crime is also included in an act of organized crime. That is how I would like to answer you.
Right, sir. Thank you. Sir, going forward to the digital crimes, you all know recently that digital arrest. Today also I read in the newspaper about such arrest. So one senior citizen was cheated for about rupees 25 lakhs. How it happens? They are telling I am a police officer and you have smuggled or you have sent some parcel to China of a drug and your Aadhaar card and everything is with us. We have filed the complaint against you. If you want to close, you pay so much. And that fellow, this particular thing happened on 20th December and few days back, that senior citizen has to pay rupees 25 lakhs. Such digital arrest, say for example, the voice of my son, they will say your son is so and so, you hear his voice and you pay so much amount, otherwise you will not do this. So Sanjay bhai, I want to know from you, such digital arrest, what are the remedies available to such type of victims? Even you can tell what precaution has to be taken while taking over such phones. Sometimes we receive a message that you have used your mobile phone so much today that it will be closed. So in such situation, I would like Sanjay bhai first to tell what precautions prior to we should take, and even if such happens, what are the remedies available to the accused?
Now, as far as the question is concerned, so any fraudster or cheater, if at all I say that means motive and opportunity, these are the three elements mainly as far as the commission of crime is concerned. So, any person by impersonation, suggesting, saying in any means or modes regarding any fact to the person aggrieved, as far as digital arrest is concerned, he might be in some sense alluring you, coercing you, or making some threat, etc. Now, as far as the word I use, opportunity, so in my view, this seems to be complemented and supplemented from the other end also. The person aggrieved, if at all he is being suggested coercively that this is going to happen, this is already happened to you, as we go through the facts, if there is some case, some enforcement, etc., regarding your presence is required, or this will be done. So, if at all such offence is committed, of course, it cannot be without the supplemented, complemented, the term element of opportunity from the person aggrieved. The offences relating to cheating, fraud, if at all some fake what documents are used, and even forgery element is there. So the penal provisions are there for affection. Now, as far as coming to the prevention part of such episodes, nowadays even in a phone call we are having any caller tune regarding this subjected circumstance. And moment one has to be careful and rather vigilant and rather prompted. If at all such phones are coming, then definitely you are not supposed to cooperate with the person making the call. But in some sense that could rather reduce such offences.
Thank you, Sanjay bhai. Because day and out, people are also getting international calls. So you should not accept, and according to me, you should delete immediately that number. Otherwise, what happens? Okay, by mistake also you will dial that number. So Kapilji, next question to you about what are the powers of the investigation authority in such situation, and what they can give recourse to the people.
So before I take this question, I just want to give a live example of this digital arrest of how people are being scammed. Recently, one of my friends was in Delhi, who was a practicing lawyer, 20 years of experience. He bought a vape online, which is not legal these days, and he paid for that vape through his credit card. 10 minutes down the line, though he was a lawyer, he got a call that I'm such and such SHO, calling from such and such police station. So you have bought this vape and I want you to make such and such payment. See, the easiest way to do it is, 10 years back, 15 years back, we started getting calls for loans. Now the ideal thing is the moment you hear that HDFC Bank loan, you just disconnect. So if somebody is trying to threaten you or do anything, 3 seconds, just disconnect and block that number. Even if there is a genuine police officer or whatever he is, attending his call is not an offense. And if police ever wants to arrest you, they will not call you that I want to arrest you. They'll arrest you and then they will tell you. We have never seen this, that I want to arrest you and, please be my guest or something. They will arrest you first. They will not call you first. So I guess the way we have been treating the other calls which are not required, whether these are promotional calls or others, these digital threat also should disconnect, stop. I guess 99% of the problem will be finished. And they're very, very smart people because they know where you have done something wrong or you have gone somewhere out of the way. They will try and pull out that information and use against you. And that is the reason people get threats. People are scared. If you're not done wrong, why will you be scared? Whatever the small issue is, ignore it. And then take a legal recourse. Now coming back to the question of cyber in case whatever it is. Fortunately, I was part of the first cyber case in India which happened in 2006-2007, which was known as DPS MMS case. And how the sir was telling, one of the person was involved because he was the owner of Bazi.com, a website. And there was a clip which was sold on his website, and that clip was sold for 12 rupees. And he has to see that litigation for 7 years when he finally got the relief from the Supreme Court, wherein the Supreme Court said the vicarious liability is not there under the cybercrime. But the other accused persons are still under trial, which is pending in Delhi, which started in 2006. From that era to now, cybercrime has evolved. But until unless I believe that with these 3 new laws, we will have to bring amendment in our IT Act as well, because that's an old legislation. Now, if you see for the first time in India, or rather anywhere in the world, earlier the general impression was if you give a statement to the police, it's not admissible. But now the law has changed. Now police, during their investigation, will record your statement, whatever you're giving to the police, again, whether it is related to cybercrime or not. And in case if they are able to convince the judge that this statement was given by you out of your free will, that can be used against you. That's for the first time. Cybercrime is now part of each and everything. Whether it is an ED scam, cybercrime will be involved. Daily excise matter. All the accused had to suffer the jail time because of not the excise violation, because the evidence related to the entire offense was related to cybercrime, because they all leave the traces, which you cannot, unless in the regular crime you can change the traces, but in digital world cybercrime you cannot change the trace. So that is the reason it's very, very important. So the protection, as one of the protection which was available, is that you don't give your passwords, they will not be able to access. But once the cops or the evidence, they have the trace, you will have to suffer the consequences.
So one more thing, when we talk about cyber frauds and cybercrime, we would have all read in the newspaper for sure. This became very, very active during the pandemic, where these Chinese loan apps, had come in, and they would do, again, it was not exactly as sir mentioned about, you give 1,000 rupees and you double it up. This was different. They said that we will give you a loan of 20,000 rupees, right? And you pay us back 27,000 rupees, example, in 1 week. And many such needy people would want to set up shops in Diwali, Christmas, Holi, Uttarayan, which is now coming up. These kind of people would go and subscribe to these loans. And obviously for those loans, they would give their, credentials like Aadhaar card, PAN card, etc. And they would have to and this is a fact because, we've dealt with many of these issues. They would have to download the app. When they downloaded the app, the entire data on the individual's phone became available to the app. Who controlled the app behind, we don't know. We believe, at least from the authorities, we get to know that these are from our neighboring sort of nations. And when the time to pay back the money came within a week, they said, okay, you had said 20,000, this is 27,000, the price changed. You have to pay 40,000. When they paid 40,000, the price changed. You have to pay 60,000. And eventually it would lead to a settlement with the threat that if you, don't pay, we will expose all your credentials, all your doings, wrongdoings, etc. to all your contacts because we have them on the phone. So this would be a name and shame thing that would happen so much and so terribly that a lot of people didn't know what to do and they would settle. And how do you go to some police station? It becomes very embarrassing as well for somebody to go and say, I subscribed to this, I did this without any credentials, without doing any KYC, and I sort of just took a loan on board and listened. But eventually it was looked at, it's a very mass kind of this app business. And while we were, as Kapil mentioned, while we doing a few ED cases, we realized, and also as actually Mitesh Bhai mentioned, that a lot of money was leaving the country. So all these, and eventually it was becoming a money laundering act, a FEMA issue, some other issues. So these were things that, which is a very small scale thing, but one has to keep in mind even today. There's one more example I want to talk about. Again, during a few years ago, a lot of us, especially, senior citizens, younger people who are not so aware of the law, the legal provisions, would get called from electricity companies. 10,000 is pending, 15,000 is pending, subscribe on this link. What was that? That was all a scam. And so many people got trapped. So this awareness and, this forum allows us to, share these views because very often we hear through the newspapers and all, but as we know, this is happening to every third, fourth, fifth person. Thank you.
Thank you. I just wanted to just complete it and you can ask questions. There are two more major important points I would like to cover and then we'll close. One important point is trespass and land grabbing. So we have a Land Grabbing Act, and I think Sanjay and Mitesh Bhai are the right person because there was some challenge at the High Court, and High Court has accepted that the Land Grabbing Act is a constitutional one. So, what are the rights available to a person, to a victim of such land grabbing and trespassing? And Mitesh Bhai, whether a person can have a simultaneous recourse under the Land Grabbing Act as well as these new criminal laws?
According to me, both remedies are available simultaneously. So a person can file a complaint of land grabbing, as well as if one is little bit aware about the provisions of Land Grabbing Act, then there is dual remedy available in the Act itself. The moment there is a registration of an FIR, ultimately, when the charge sheet is laid, it would be for the concerned judge not only to proceed pursuant to the initiation of criminal prosecution, but so far as civil remedy is concerned, that is with regard to restoration of land, if my land is grabbed and the person who is the grabber would be an accused in a criminal trial, but it would be for the judge as well as for the aggrieved party to convince the judge that though I have initiated the proceedings under a criminal law, that is a criminal feature of the Land Grabbing Act, but as I intend to get my land back, which is grabbed by so and so, then the civil suit also can be initiated, the civil remedy can also be initiated. And out of both proceedings, it would be for judge to decide that which proceedings has to be completed first and which at the subsequent stage. So this is how Land Grabbing Act stands for both the remedies are concerned. Can be pursued simultaneously.
Yeah, land grabbing act, as Jatin Bhai said, it is required to be known. Police cannot register FIR directly. Firstly, there is a mechanism at district magistrate office. You have to file your complaint, and they would verify the contents. And after verification of the contents of your allegations, it is recommended to the police to file an FIR. Now, as far as the prosecution of land grabbing offences is much easier, because the owner would not having the possession, and the possessor would not having the ownership rights in terms of any documents, etc. The person claiming ownership would be admitting the possession, and as per that law, even attempt is offence, and he would not be having any ownership document admitting the possession, so it becomes easier for the prosecution through the charges signature.
Thank you, Sanjay bhai. The last topic, there are so many topics, but I would just touch the last topic now. It's we are hearing in newspaper every 15 days or so, hit and run. Say section 106 deals with that. Sanjay bhai, just can you throw light on this? I think the provisions of 106 have not been made operative due to certain provisions which are stricter one. But Sanjay is the right person to guide us.
Yeah, as far as more or less in common of the vehicular accidents, of course, apart from that, the element of rashness, negligence would attract such offences. Now, more particularly, as Jatin bhai has hit and run, it's a common word we have hear it. Now, as objective, moment there is a vehicular accident, and if at all the person accused or suspected of it informs the police or the magistrate, then of course the gravity and subsequent punishability is reduced. Of course, it has been increased up to the 5 years, which was not in the earlier law. Now, as far as when I talk about the rashness and negligence, so for medical professionals, of course, registered medical practitioner, the punishability is up to 2 years in such fatal act resulting from rash or negligent act. Now, in another case, which is required to be noted and be aware that if at all some accident is being done, and if you are running away from the spot without informing the police or magistrate or even some doctors, etc., then of course the punishability is up to 10 years, and that aspect of police offense is made non-bail.
Thank you, Sanjay. With this said, I think there are other couple of subjects, but with the paucity of time, we will not take it forward. But I will request at least not more than 3 questions from the audience. Yeah.
Not this digital error. Should it really be described as a cyber crime? To me, it appears that it is more stemming out of social behavior. Because general public believe that if you want to go to the police, police will always extort the money. So it is natural to pay the money and get out of it. And instead of challenging the police, the general public thinks that no, you should carry on.
See, as far as the question regarding any context of the working method of police, I think that is not required to be answered. As far as your question seems to the extent of any grievance regarding non-lodgement of complaint, there are remedies.
So just one more thing. Again, if the action or the crime has happened through a medium or a device, such as a phone or whichever, that's how a digital arrest would happen. It would qualify as a cyber.
But that reflects the social behavior of the public. That they do not really, even if the police officer is doing wrong, he doesn't want to challenge it in the court or go to an advocate that this is the wrong thing done to me. He would rather compromise and pay the money and get out.
That's not truly true, I guess. See, for example, you are on the road and you have not jumped the red light. Will you ever pay to the cops to answer it? But if you have jumped the red light, then you are taking a shortcut. It's not good that we should blame police on each individual. I believe if you are on the right path, you will be resident to pay anything to the cops. It's both the sides. If you take a stand, I guess there are people that was
Otherwise, collecting 1100 crores in a digital arrest.
No, just, sir, we can have just offline discussion because we should give some opportunity to others also. Just one small question.
So my question, as additional AGs have mentioned that we live in a digital age and digital crimes are occurring. Most of the digital crimes are utilizing AI. And as of now, India doesn't have any special law regarding AI and its crimes. It is governed by IT Act and other guidelines by the Honorable Apex Court. So according to you, does India have a requirement to have a special law for AI, and what 3 key provisions would you keep if you are going to draft the law? What 3 key provisions regarding AI laws or cyber AI crime related laws would you keep in the statute if you are drafting the law?
Okay, I'll just take a shot. So I think great question. It should, but hopefully the Information Technology Act of 2000 should be now, at least in our view, or we were talking separately, should be updated, as of today, because there are so many concepts such as what you talked about, or what we've been talking about, deepfakes or phishing, which is not recognized. We're all going and interpreting this in various other, sort of through other laws to come to the aid of, the resolution of the issue. As far as what should be included in the act, I'm not a lawmaker, but let's assume I'm sitting in that chair right now of a lawmaker. I would say that it should be a cross-border, very wide and far-reaching kind of a law. It should not be jurisdiction specific because this can happen from anywhere, right? That's number one. I'll give Kapil the opportunity to answer.
See, if I have been given a chance instead of making a good law and make a stringent law. See, why the cybercrime is happening is twofold. Anybody can go and buy a mobile SIM card. If you make it a must, like in US, until unless there is a security number, you'll not be given anything. And that is what the government is trying to do with our Aadhaar and PAN card. If you have a genuine Aadhaar card and if it is linked to your mobile or the phone number, you will be scared to do crime. Similarly, if your internet users, if the law has recognized that the right person is using, and we have all the details, then you will again be, scared of committing a crime. In the AI age, if you are giving a new law, whether it is on Android or whether it is on an iPhone, if there are stringent conditions to register your app, where your bank credentials are mapped, your identity is mapped, each and everything is mapped, you yourself be so vigilant that you will not allow the other person to commit crime to your app, because the responsibility will rest with you. See, laws are there. The only thing what is missing in India is stringent implementation. You go to Europe, you follow each and everything. You go to US, you follow each and everything, because it's scale of those laws. The moment we will have implication of law in place, I guess we have excellent laws in our country. The only thing is, size of the country is so, the population is so huge. That is the whole problem. But we are on right track, and I guess 10 years down the line, inshallah, everything will be fine. Let's hope for the best.
Thank you. Now I invite Jatin Trivedi to a vote of thanks. Prior to that, I also would like to compliment three persons who have worked with me. Mr. Rahul Pandya, Mr. Jay Upadhyay, and Mr. Monarch. They were the three people for the same day. And before Jatin will give vote of thanks, let me put a disclaimer that this particular whole seminar, that is conference, is the questions which have been asked by me are my own questions. Similarly, the esteemed panelists who have given the answers, these are only their views, and therefore this cannot be considered completely, because it's a disclaimer while closing this criminal conference. Thank you. Jatin.
Basically, no free advice.
Free advice may be offline.
Lawyer doesn't mind by the bare words, usually. So, nonetheless, good evening, friends. Thank you, Jatin bhai, for a wonderful moderating. First of all, big round of applause for the Jatin bhai, because he's the one who has designed the entire panel. As being a chair to the legal committee at the Gujarat State Council, he's been looking for this opportunity, and thank you, Mitesh bhai, for giving us that opportunity to design this. Mitesh bhai, it was really, I would say, really great pleasure to hear you, as from out of the court, right? We keep on hearing you every time in the court, but this was completely different. So thank you very much for your insightful thoughts on how it is shifting the paradigm from the old conventional laws to the new criminal laws with a few amendments. And I really appreciate the government that there is a need of an hour, and the government has come up with the idea or the amendment. Obviously, experts have suggested, and government has agreed to that as the zero FIR. That is something which is really commendable. And for the general public, zero FIR is something which is very useful for every citizen of the country. And I'm sure that, we all will be getting benefit out of it. Not today, maybe tomorrow, or maybe day after. I wish nobody required that, but still it is very easy, and it is very citizen-friendly amendment which is brought by the government of India. So a big round of applause for the government of India on that. Sanjay bhai, I would say Sanjay bhai is like a dear friend to us, and Jatin bhai, I take a privilege of saying that he's not only a retainer for Adani. Probably if you ask the practitioner sitting here, is almost retainer for everybody. So every practitioner, irrespective whether he is into the IP or not, but Sanjay bhai is the one person to go in case if you have any criminal advice or any matter which is pertaining to the criminal law. Sanjay bhai is the encyclopedia. Undoubtedly, the designer of the encyclopedia is sitting beside him. So Mitesh bhai is the mentor to Sanjay bhai. So we have a two doyen of the from the Gujarat, and they have changed the Gujarat criminal law as of now more favorable to the citizens. So thank you very much. Yes, 100%. Sanjay bhai is even Mitesh bhai was also right. So nonetheless, Alok and Kapil, Ankush and Kapil, we being a little biased, being a Gujarati, because these two are the Gujaratis. Oh, you're Gujarat, right? But from Gujarat, right? So in a Gujarat, we always say that the bhai or a band. When we say bhai or a band, they become part of the family. But nonetheless, you are also part of the family. So Kapil and Ankush, thank you very much for your practical experience sharing. Thanks, participants, students, practicing lawyers, and some of the distinguished guests from the AMA, from the FICCI. Thank you very much for your presence and make it little more active. For the question and answer, I think you can take it offline. And thanks to Press and Media for support. Thank you very much once again, and we'll join sometime soon. Mitesh bhai will require your expert guidance before you are preparing something note on the thing. Yeah. Thank you very much. Thank you all. Good evening.
Yeah, Ajay bhai, band kar do.